may be seated.
Counsel for the first case, Steel Metal versus, Stromberg Metal. We're ready to hear you.
Mr. Pierce?
Yes, Your Honor.
Good to have you here, sir.
Thank you. It's very nice to be here.
Apologize to you for the delay. We've been involved in other proceedings.
I understand. Yes, sir.
But we're ready to go and look forward to the arguments of you and your fellow counsel.
Your Honor, this is an ERISA case.
You can take that mask off.
Oh, yes, yes. Thank
if
you.
You'd like to. It's up to you, but
I thank you.
You're free to do so.
This is an ERISA case in which the plaintiff funds claim that they are due contributions consistent with a staffing ratio that is contained in a collective bargaining agreement. This case was resolved by the lower court on cross motions for summary judgment. The lower court ruled in favor of the plaintiff's motion and against Stromberg's motion by making two conclusions. First, the court concluded that those staffing ratios did relate to the contribution rates. And second, that Stromberg had not complied with the correct ratio that would be applicable. We submit that both of those conclusions by the trial court were incorrect, and that in fact, if this court were to determine that either one of those conclusions was incorrect, then summary judgment should be granted in favor of Stromberg Metal.
Well, let's assume we don't agree, we stay with the 1-2 ratio. You've contended throughout that it should be a 1-1 ratio, and your accountant, or Ms. Bigelow, made an unsubstantiated statement to that effect. Where's the evidence that goes against the 1-2 ratio? Because the auditors also put in their report they did this on a 1-2 ratio.
Your Honor, first, what Ms. Bigelow said was, and to get the numbers right, yes, the collective bargaining agreement by itself has a 1-to-2 ratio, 1 journeyman to 2 non-journeymen. But the parties entered into two amendments to the collective bargaining agreement that are referred to in the sheet metal industry as Resolution 78s. And those Resolution 78s, those amendments, which the other side acknowledges are controlling documents, they come up with a 1-to-4 ratio. And so that is a controlling document for the 2 big jobs, which the plaintiff acknowledges is the crux of this case.
So you say it should be 1-to-4?
Yes, Your Honor. For those 2 jobs, which, as once again the plaintiff says, that's the crux of this case.
And Judge Boyle applied 2-to-1, 1-to-2.
That is correct, Your Honor. What I want to point out is, I mean, there's no dispute that it is a 1-to-4 ratio for those jobs, but what the lower court did was to say, well, there's an excuse for not applying the 1-to-4 in this case. And they came up with 2 excuses for not applying the 1-to-4 ratio. The first excuse was that, we didn't keep good enough records to apply a 1-to-4 ratio. But the evidence for that comes from the declaration of Mr. Kenneth Anderson, and Mr. Anderson makes it very clear that he has no idea what the records were. He says that that's what the auditor, some unnamed person, thought that the records showed. So that was clear hearsay in and of itself, and it should have been disregarded, and that would have been the end of the story right there. And so the 1-to-4, which the other side acknowledges is the appropriate ratio, as long as there's no excuse, the 1-to-4 should control.
Well, one thing in this case, and you just have to help me out, it seems to be like you're conflating hearsay with authentication. And the report got in without objection as to its authentication. Is that not right?
No, the 2 are very separate. And the point is that, Rule 56 has been amended some time ago. The plaintiff, any movement on summary judgment is not held to a strict standard of authentication. The point is that nobody has ever said that these documents are audits. No one has ever said that these documents are accurate. no witness has ever come forward to say, oh, yes, these are the audits, or these are accurate, or that there's summaries.
Did you object to authenticity?
Yes, Your Honor, I did. And the way I did it was by pointing out over and over and over again throughout the entire case, including in the last thing that I filed in this case, that these are simply alleged and purported. And that is authentication, because all authentication is to say that something is what it purports to be. And when I say they're only alleged, then I am acknowledging that they are not. And until someone comes forward, some witness comes forward and says, here are the audits, then there's nothing more that I need to do. But the point is that they are hearsay documents. They're clearly.
Did you ever say they were not authentic? You did say they were hearsay. You kept saying things
Yes.
were hearsay.
Yes. But I want to be clear.
Does that mean the same thing? Is that what your position is?
I do not.
That preserves an objection as to authenticity? That by objecting to hearsay.
No, Your Honor, that is not my position. Those are two separate things. And I'm making clear they're two separate things. And I want to be make it clear to the court. I never said these are not authentic. What I said is these are only alleged. And that was enough because they have never had any witness in this case come forward and say that what they are. No one's come forward, no witness has come forward and said, here are the audits. So, number one, that is a separate issue. So if the court were to say, for some reason, that's a waived issue, okay, well, then we go to hearsay. And they're clearly hearsay. And what the plaintiff funds are trying to suggest is that there must be some sort of...
Reports are introduced all the time in trials, in litigation.
If someone can introduce them, but no one's made any effort to introduce them. No, here's the point, Your Honor. We have, throughout the case, we've called out the fact that no auditors come forward in this case. And no one said that these reports are accurate. And we have affirmatively stated on a methodology basis that they are inaccurate. And when we called them out on that, it would have been very simple for them to get an affidavit from the auditor that said, oh, these are the reports, and yes, they're accurate. But they won't do that. And they won't do that because the auditors know that these reports are not accurate. We found one of the problems, and to come back to the point is that, the 1-to-4 ratio is that the only reason they didn't apply the 1-to-4 ratio is because they said that we didn't have the records. And Ms. Bigelow stated unequivocally that we do have the records. And so that was a contrary bit of evidence. And with that contrary bit of evidence, that kicks out the reason for not including the 1-to-4 ratio.
Well, you are talking about hearsay and authentication and accuracy, right? And
yes.
You definitely raised a hearsay objection below and maybe not authentication.
Yes.
But my understanding of the hearsay objections usually say you can't enter a report unless you have someone who knows how the report was generated, right? And there's arguments in front of us about were they all treated as journeymen? Did the 1-to-4 apply? Who should it apply to? How was this report made? There are questions about that in front of us that seem to go to hearsay more than they do to authentication or, you're characterizing it as accuracy, but we don't know if it's accurate if we don't know how they arrived at these conclusions in the report.
That's right. We don't know anything about these reports, Your Honor, because no witness has come forward to say anything about these reports. These reports were attached to the declarations of Ms. Morris and Mr. Anderson, and they never even acknowledged there were any attachments to their declarations. It seems obvious that they had no idea there were going to be these documents attached to their declarations when they signed their declarations.
Now, the records underlying this audit, of course, are the employer's records. They're your client's records. But the audit does something to the records, right? It analyzes the records in a certain way. And is that what you're claiming we don't have insight into because of the hearsay problem? Is the terms of the audit, not the contents of the records?
Yes, Your Honor, that is correct because, the initial point is whether or not these staffing ratios, which exist in countless collective bargaining agreements across the country, in any way relate to contribution rates. And they don't even apply to the contribution rates because the two are separate from one another. They don't talk about one another. There's never been a case as far as...
Isn't that kind of a contradictory argument? Because I was confused by this, and I'm not accusing you of contradicting yourself. I'm asking you to help me. There's an argument that the 1-to-4 ratio applies, and you argue about, is it 1-to-4 or is it 1-to-2? But there also seems to be, maybe it's not fully fleshed out until your reply, but looking at this document myself, and you make this point in the reply, is the temporary employees, it looked to me, they're all classified level, which is a different argument than 1-to-4. It's saying that they all are this one level and we don't need a ratio, that they're just all classified. And are those arguments compatible? Are they alternative arguments you're making? Or, am I off base on thinking that's even an argument you're advancing?
Well, Your Honor, what I would say is there's a great deal of confusion in these reports. I mean, no one, in addition to no one ever offering the reports, no one's offered to explain what these reports mean. And you can't do that. I mean, I can...
What's your position on, should the 1-to-4 ratio apply, or should all of these employees or all these workers be categorized as classified employees? So there's no 1 in the 1-to-4. It's 5 across the board. They're just all the same.
The 1-to-4 ratio should apply to the Resolution 78 jobs, which are the vast majority of what we're talking about. And Ms. Bigelow, in her declaration, said that's exactly what we did, and that is undisputed. It's undisputed that we were within the ratios. Now, it's our position we didn't have to comply with the ratios. We pointed out in our brief these are two separate things. They don't refer to one another. Even the union acknowledges that's not the purpose of the staffing ratio. It only relates to job productivity and nothing else. That's what the union says, and this is a contract between the union and the employer, and I would suggest that what they say should be given great deference so long as they're not saying something inconsistent with the contract.
So you're saying both?
I'm saying, one, the ratios don't apply. The staffing ratios don't determine contributions. Those are two separate things.
But you argued in support of the 1-to-4.
1-to-4 is, here's the point. We had an independent contractual obligation to
find out what your position is. I thought that Judge Boyle applied a 1-to-2 ratio.
Yes.
As I recall.
Yes.
And I thought you said that's wrong. It should have been a 1-to-4 ratio.
Yes.
So, but now you're saying that's something else.
No. It should have been 1-to-4, and he came up with two excuses, and the excuses were, one, relied upon hearsay evidence, which was directly contradicted by Ms. Bigelow to say that he had no idea what it was.
It's fair to say that Judge Boyle came up with excuses. You said that Judge Boyle came up with excuses. I don't like that.
All right. He came up with two reasons. He came up with two reasons. One of them is that we did not have good records, and we have... And consistent with this court's Jacobs decision, he had an obligation to consider Ms. Bigelow's declaration that said our records do have that, and Mr. Anderson has no idea. He had pure hearsay, and all he said is, well, you didn't produce documentary evidence. At very best, that goes to the weight of that evidence, which should not be judged at summary judgment. His other excuse is said that we didn't allow these people's skill to be evaluated so they would know what class they should be in. There is nothing in the record that supports that the skill is to be evaluated. To the contrary, the declaration of Mr. William Blank makes it very clear that that's not what determines if you're a journeyman. You could be the very best sheet metal worker in the world, and that still doesn't make you a journeyman. If you're a journeyman, the local union has your name on a list, and if you're on the list, you're a journeyman, and if you're not, you're not, and that determines what you are. And if the court has no further questions, I'll sit down. My time is up.
Very good. You saved some time.
Yes.
Ms. Campbell?
Good morning.
Good to have you here, Ms. Campbell.
Thank you, Your Honor. May it please the court, my name is Carla Campbell. I'm here for the plaintiffs' appellees in this case. I will jump right to the court's questions and Mr. Pierce's arguments about the ratios. Before I do that, though, I just want to mention what is on appeal here are questions about damages.
About what?
Damages. The Stromberg has not appealed before this court the lower court's determination of liability. They have not appealed the district court's analysis of the Darden factors, the employee-employee relationship. We're really here just about damages, and so I will direct my attention to that.
Question of how much?
Exactly, Your Honor.
And what do you have to say about this hearsay, authenticity stuff?
Excuse me. We do not believe that the audits are hearsay. We mentioned before the district court that these are audits by nature are summaries of Stromberg's own employment and payroll records. They're classic Rule 1006 summaries of voluminous records. They're not hearsay under 801 because as summaries of Stromberg's own records, they are essentially admissions of a party opponent.
But the records aren't, your audit's not being used to prove the contents of voluminous records, right? The point of the audit is not to say, well, there's too many employment records, so we're going to put it in a easy to understand chart, right? The audit does something to the records. It applies a method to the records and comes to a conclusion. So I don't see how Rule 1006 gets you over the hump.
Okay, then under Rule 801D, these are admissions of a party opponent. They are statements by an auditor who was a person authorized by Stromberg themselves as signatories to this collective bargaining agreement to come in and audit their books, to do this audit process and provide the funds the information that they need to be able to pursue collection. That's largely what we argued before the district court. Alternatively, I would say that these are Rule 803 exceptions to hearsay. These are records of regular business activity, the funds. We've put them into the record using the testimony of Mr. Ken Anderson, Mrs. Deanna Morris, Mr. Don Detty, who were all employees of the fund or third-party administrators.
Did anybody say they were business records of the fund that's in the record here?
They did not say these are business records. They said that these are records records of the fund's regularly conducted activities. And so
that sounds like about the same thing I asked.
Okay, I just want to use the exact language of
the records of the fund's, what'd you call it, regularly conducted activities?
Exactly.
That's in the record. Where is that, in the declaration?
It's in the declarations. There's also testimony from Mr. Nicholas Brazel, who was the 30B6 deponent representing the health fund in this matter, who talked extensively about the fund's regular processes.
So I thought I read the declarations and it didn't mention the audits. It didn't mention the attachments. Are you saying that the declarations actually say the audit summary that's attached is a business record?
It does not say
or a regular, a record of our regularly conducted activities.
It explains the fund's collection activities, and then it said it received this audit summary from the third-party auditor, Caliber CPA Group. I wish that it had another statement that said, which is attached here to as Exhibit A, we wouldn't maybe be having this argument, but it is quite obvious the dates match up between the declarations and the audits themselves. I would say if
they marked as an exhibit or anything, is there a number on them as like Exhibit 1, or I'm just trying to get it straight, but you say that they're attached to the declarations.
Correct, and just so...
They're filed at the same time as the declaration?
Exactly, just for the court's ease of reference, for example, Joint Appendix 2005 is one of the audits. You can see right below the page number, it has the date. a few pages before that, Joint Exhibit 2002 is the declaration of Mr. Anderson, who says, I received these October 22nd, 2020 audits, same date, from our third-party auditor that shows, and he goes through the delinquency that it shows. It was attached to that and filed simultaneously.
Who's the third-party auditor?
Caliber CPA Group.
Does he have that name in there?
Yes, correct.
Is that name on the audit that's attached somewhere to the declaration?
I don't see it on the summary. I don't want to belabor the court's time by looking all the way through it from the first page. I will say that multi-employer Taft-Hartley funds use this process regularly. There are other cases, district court cases from the circuit. The Raby case we've cited extensively, the conditioned air court, in which very similar declarations from multi-employer fund employees were used to introduce audits that the calculations were based on. If the court finds that insufficient, then we would ask the court, if the court is inclined to remand just the question of damages to the district court. I do want to address a few comments made by opposing counsel about we are happy to go back to the district court if we believe that you can affirm, obviously, but we are happy to go back to the district court and introduce an affidavit from the auditor, Caliber CPA Group. The auditor has always been willing to participate in this lawsuit.
Why didn't you do all that at the time you were in the district court?
We just made a decision that what we presented was sufficient. We went back and looked at other district court cases that found those similar types of audits to be sufficient, and we made a judgment call about cost. If we made the wrong call, then that was on me, and we are happy to go back to the district court and present an audit or a declaration from Caliber. We disclosed them in our Rule 26 disclosures.
Have you requested or you thought about requesting to supplement the record on appeal?
We did not consider that.
There's a provision in Rule 10E of the Rules of Appellate Procedure that permits a party to request the Court of Appeals to accept a supplement to the record on appeal if the circumstances justify it, whatever the terminology is. You lawyers can look at it. I'll leave it. That's up to you.
Well, look at talk about Section 1059A1. At least two of our sister circuits have concluded that when a plaintiff proves the fact of liability, the burden then shifts to the employer to prove damages. Did they offer any evidence on the damage question?
No, Your Honor, and thank you for that question. I think this might clear up the issue of the different ratios. I was going to say, as a segue into Your Honor's question, if the court were to remand it or ask for further information about which audits should be applied, frankly, we will get to the same conclusion. We will apply the 1 to 2 audit precisely because Stromberg did not keep the 1-to-1 ratio is not in the collective bargaining agreement in any place. The 1-to-4 ratio would have applied on specific job sites, not across their entire employment practices, if they had kept adequate records in order to do that, as they should have done under Section 1059. And so our auditor and also the declaration of Mr. Anderson show that those records were not sufficient for us to determine which particular job sites.
There's a dispute of fact, right? Is there a dispute of fact between the parties on whether what was given to the auditor was sufficient?
The auditor went to Stromberg's workplace and combed through their own records. So if the auditor did not find it, it's because it does not exist.
But my question is, we're on summary judgment, and the court granted summary judgment in your favor. And so if the funds say the accountant told us that they didn't have sufficient documentation, and the employer says, we did give them sufficient documentation, and if they needed help interpreting it, we would have helped with that. And the court concludes, the parties disagree about this. On summary judgment, doesn't it have to draw the inference in favor of the party who's not moving for summary judgment?
We agree, the plaintiffs agree with the district court that single statement in a declaration by Stromberg saying the auditor's numbers were wrong without any documentation to show in what ways they were wrong is insufficient to create a genuine issue.
Well, you have a single statement from someone who's not the auditor that the auditors told me they didn't have sufficient documentation, and they say you did have sufficient documentation, and so it seems like there's a dispute about a fact that's material because the reason they applied 1 to 2 was because they didn't have the documentation.
Certainly it's material. I wouldn't disagree with that. I would say that single statement is not enough to create a genuine dispute in light of not only the audits that I just referenced, there were several prior versions, draft audits.
But you agree, right, that the 1 to 4 ratio does apply to some job sites that some of these workers were on. It's not as though you just have an isolated statement that, one person at the employer says, no, everything the auditor said is wrong. That wouldn't get over the bar, right? But there's evidence to support it, and you don't dispute the grounds for it. But the reason that 1 to 4 wasn't applied at all was because of the deficiency, and the district court didn't resolve whether there was a deficiency. It just accepted one side's argument on it instead of the others.
It accepted one side's argument, which was supported by documentation, by Stromberg's own admissions. I'm happy to go through those. In the record were Stromberg's calculations of the hours that they owed, monthly reports that they submitted to the funds, statements of accounts, records that were subpoenaed from the temp agencies, Ms. Bigelow's own admissions that they did not keep detailed records about these workers from the temp agencies, such as Social Security number, job classification. There simply was not enough for anyone affiliated with the plaintiffs, whether they're in-house folks or a third-party auditor, to go through and determine how individuals that had come from a staffing agency to work for Stromberg, which particular job site that they were working on which particular days. And that is what, under Section 1059 of ERISA, that is what Stromberg had the burden to prove, if they wanted to apply a lower ratio than what's mandated by the collective bargaining agreement.
Well, as a matter of fact, there's some case law out there that when you have inadequate records, there is a just and reasonable inference as to the amount of damages owed, and I assume that's what Judge Boyle did.
Correct. He applied a default ratio, which is the 1 to 2 ratio in the collective bargaining agreement. He did that because Stromberg was not able to prove the 1 to 4 ratio that they were advancing. In Raby, the court said, District of Maryland Court, Raby's speculative and unsupported conclusions are sufficient to establish a genuine issue of material fact with respect to the audit's conclusions. The same type of argument in conditioned air system from the District of Maryland. All of those are based on Section 1095, which imposes the burden on the employer to come up with specific detailed evidence, not just a single conclusory statement if it wants to contradict the fund's evidence. It's kind of like in the context of the FLSA that the employer has the burden to prove damages if it
so the default provision would be because the main collective bargaining agreement had the 1 to 2 ratio. And in instances where it would have been a 1 to 4 ratio, if there are inadequate records to establish that,
correct,
then you would go to the default position.
Precisely.
And the Supreme Court has allowed that to happen.
Precisely, Your Honor. Yes, the collective bargaining agreement has a 1 to 2 ratio.
That's where Judge Boyle got it?
Precisely. It's in the collective bargaining agreement. I can give you a citation if you want. The 1 to 4 ratio is something that the union who's not a party to this, one of the two unions who's not a party to this, negotiated as kind of a special ratio with Stromberg that would only apply to 2 specific jobs at issue. The rationale behind that is it helps folks like Stromberg to be able to competitively bid those jobs with a lower staffing ratio. The plaintiff funds were not participants in that, but we have always said we would honor those 1-to-4 ratios on those specific jobs if they were able to provide us with documentation to show which temporary worker worked on which job, how many hours a day on that job, which is what they would have to do. And they have
back
not.
to Ms. Bigelow's, y'all seem to have some difference of opinion about the value of her testimony. What is it she said or didn't say that helps you?
That helps me. Ms. Bigelow did talk a lot about, in some of her affidavits, the back and forth that's involved in the audit process. It's not like an auditor just goes and then produces a report. There's months. In fact, this audit lasted almost 2 years. There's a lot of back and forth. In that same declaration, Ms. Bigelow does say that, I think it was in the context of Stromberg was making payments for these temporary workers for some period of time and then stopped.
What did she say that hurts you?
She said that hurt us is this single statement that she said that, yes, we did provide the auditor with sufficient records to establish the 1-to-4 ratio.
And why is that not a dispute of material fact? You have one witness who says they didn't give us the records, and one witness who says we did give you the records.
It's not a genuine dispute of material fact because we have substantial documentation that I just mentioned in the records.
You have more evidence that they didn't give you the records.
We have all the evidence. We have documentary evidence.
But they have someone who would be the person with knowledge about whether they gave you the records saying, we gave them the records.
Right, without attaching any of those records to her declaration, without ever providing those records. And so my point is just that a single collusory statement, which is contradicted by all the record evidence before the district court, is not enough to satisfy the employer's burden under Section 1059 of ERISA.
Well, they're trying to prevent summary judgment. They're not carrying, there's no burden on them right now. You only get to, as I understand what you're talking about, flipping the burden, is if you don't have sufficient factual, you don't have sufficient records from the employer, right? And so that's the whole question is, were there sufficient records from the employer? And I just don't know how Judge Boyle resolved that in favor of the party moving for summary judgment.
Okay, maybe I could frame it in the context of Rule 56. So Rule 56, Federal Rule of Civil Procedure 56 puts on, I believe it's C2, puts on the non-movement the obligation to come forward with evidence sufficient to create a genuine dispute. And so our position is, in the face of all of the records, the documentary records and the evidence that I just mentioned, that doesn't create.
Your opponent draws a red light comparison, right? That, you have one driver who says it was green and one driver who says it was red. Imagine the driver who says it was green also has, 3 other witnesses who say it was green and, some sworn affidavit, they have more evidence. But you still have one person on the other side who says it was red. Why is that not a material dispute of fact?
It is a material dispute of fact. It's not a genuine material dispute of fact. So
you think the person who says it's red, we could grant summary judgment against them? Say no one agrees with you. 3 other people say it was green. We're throwing you out of court.
If the person who says it's red has 3 other people on the other side saying it's green, and then to use the analogy, if the court were to send this back to the district court or ask for a Rule 10e supplementation, and I provided an affidavit from the auditor who also says it's green, which in that context would not only be an affidavit, would be equivalent to a video camera showing that the light was green, then yes, that's precisely my point, is that under Rule 56C2, that's not a conclusory statement that's overwhelmingly contradicted by evidence is not sufficient.
Right, the photo would be different, right? If you had a photo of it at the time of the accident, right? Which I guess the analogy here would be if you presented to the court, here are the records and here is how it's impossible to get a 1 to 4 from it, right? And then the other side says, no, actually, here's how you read the records, and there's a discussion about how to read the employer's records. But here, the court just said, Mr. Anderson says that the auditors told him that they didn't have the records, and that seemed to be the whole basis for it.
And maybe the auditor, a declaration or an affidavit from the auditor would essentially be equivalent to a photo. And again, as I've said, we're happy to introduce that. I can represent to the court exactly what it will say, which is that the light was red. So it will say exactly what Mr. Anderson said, and it will say exactly what the district court said. So I will mention on the comments, so I only say that because Mr. Pierce suggested that the auditor would never show up and present testimony. That's not accurate. They would have been happy to do that. The 1-to-1 ratio is nowhere. I'm still not clear what ratio it is Stromberg has asked this court to apply, or what they asked the district court to apply. Again, we would apply the 1 to 4. The 1 to 2 is in the collective bargaining agreement. We would apply the 1 to 4 if we had the records to do it. A 1-to-1 ratio, or classifying everyone as a low-wage classified workers, simply has no basis in any of the agreements between the parties. I see that my time. Yes, yes, it is. So.
Any other questions? Thank you very much.
Thank you.
Mr. Pierce?
Your Honor, Stromberg most certainly is contesting liability. I mean, we've asked that summary judgment be entered in our favor, and one of the principles for that is because these staffing ratios, which are very common in collective bargaining agreements, simply do not relate to contributions. Those are two totally separate things. We've pointed that out in our brief, and if the court decides on that point, then that's the end of the case right there. We were consistent with the ratio. Ms. Bigelow states that unequivocally, and no one has ever contested what she said. I mean, what she said is that we were in compliance with the 1 to 2 ratio for the 1 to 2 jobs and the 1 to 4 ratio for the 1 to 4 jobs. So we're totally consistent. And there's the suggestion now that, maybe there's a hearsay exception. That's never been suggested before, and there clearly is no hearsay exception for privately retained auditors' reports. And that's what we've got here. We don't have any witness who says that these are audits. We don't have any witness who says that they are accurate, and we certainly don't have any witness who says that they are summaries or accurate summaries.
Do you agree that you do have liability, or you suggest you don't owe the fund anything?
That is correct, Your Honor.
You say you don't know anything.
That is correct, Your Honor, because they're basing it upon these a couple of reasons. Number one, the staffing ratios don't control contributions. Number two, even if they did, we were in compliance with those ratios. And Ms. Campbell wants to suggest, well, we've got a lot of records. She's not saying that the records have been submitted to court in evidence. I don't know what records she's talking about. When it comes to establishing whether we had accurate records for the auditors, she's also suggesting, well, the auditors did this, the auditors did that. There is no evidence from what the auditors did. All we have is hearsay evidence. More than anything else, what this case is about.
The declarations.
Yes.
The declarations are in the record.
But not of the auditors.
The declarations don't have to be of the auditors. They have to get them. She says she can spruce them up and say they're records of the company.
Those are not records of the company. And to answer a question that you had, the name Calibri does not appear on any of these attachments that are unidentified to these declarations. So I want to point that out.
Did they do an audit of your records?
We know that the people from Calibri came down and looked at our records. We talked to them. We answered all the questions that they had. Whether they ever completed an audit, we have no idea.
Well, did you offer any calculations to show that you owe no money?
Well, Your Honor, there is no calculation to show that we don't owe any money. I don't know what calculation. I mean, we have offered the auditors a lot of information, and we showed it to them, and based upon what we showed to them, that would show that we don't owe any money.
Well, it seemed to me that the way this thing got off track is a temporary worker situation got out of hand. And that's what it appeared to me at the end of the day. There weren't any records about temporary workers. That just, it's my surmise that it's the temporary worker situation that has gummed this thing up.
Well, that's what started, but no, there was more than adequate records about the temporary workers, Your Honor. The point is we know the hours worked, and that's all the contribution requirement of the CBA requires. All you do is you look at that classification, and they all would have been classified workers, and you look at the hours worked, and that's how much is owed. And you don't go to any kind of ratio to say, well, even though you're not a journeyman, we're going to require contributions as though you were a journeyman. That would be inconsistent with another provision of the collective bargaining agreement, and it's a general principle of contract interpretation. You don't interpret provisions to be inconsistent with one another. And once again, you know, even the union agrees with our position. That's not the purpose of the staffing ratio. And so what we have here is the only reason that the court below gave for not applying the 4-to-1 ratio, which Ms. Bigelow unequivocally, without anybody disputing, said that we were in the 4-to-1 or 1-to-4, is that we didn't have the records. And I do understand that there is authority that says, well, if you don't have the records, then yeah, it can be held against you.
That's a valid reason, right? That's a valid reason.
If that were true, but we pointed out that.
But you said there's a declaration that said that.
Our declaration says we have the records. And that is the only competent evidence on that point. Their evidence was pure hearsay evidence. More than anything else, this case is about summary judgment procedure and hearsay evidence. Everything that they brought to you is hearsay evidence. There's been no witness who's made any reference to these documents they want to rely upon. And they're saying, oh, yeah, we got lots of records. Well, they've not been made a part of the proceedings here. And I will say this, is if this case does have to go back to the lower court, I would certainly request that this court rule on that issue of whether or not.
What?
I would request that if this court thinks that it's necessary to be remanded for anything, and of course, I would hope the court would rule totally in my favor. I acknowledge if you rule totally against me, that's the end of the case both ways. But if it goes back on some sort of remand, it is my request to the court that you do rule upon this issue of whether or not the staffing ratios have anything to do with contribution rates. That is the initial question, which the court below gave very little attention to. We pointed out that the two have nothing to do with one another, and to try to apply them, which no other court has tried to do, despite this being a common provision among collective bargaining agreements.
You're asking us to give an advisory opinion on a matter that's involved in the labor?
No, Your Honor, I'm asking you to rule in my favor completely and dismiss this case. That's what I'm asking. But if I'm asking that summary judgment be granted in favor of Stromberg, Your Honor. I'm just saying that the court's going to do what the court's going to do, and I just want the court to be very well aware of this initial issue. It's purely a question of contract interpretation that I believe this court could handle. And if it has to go back, then I think it would be appropriate for that to be resolved, and I would make that request.
I have one more question about that
Yes,
ratio business. The reason you have a ratio is like for the journeyman, their contribution is more than the other three classifications. And so you establish the ratio as 1 to the journeyman, and it takes 2 of those lesser classifications. You make a contribution equal to the journeyman's contribution by combining 2 of the other classes. Is that the way it works?
I'm not sure.
And if you had the 1 to 4, one journeyman, and it would make X contribution, it would take contribution from 3 of the other categories to equal a journeyman's. And that's the requirement of, that's how the sum of money is calculated.
As I understand your question, no, Your Honor, I would disagree with you on that point. The number one, as the unions pointed out, and we agree, the purpose of the ratio is to establish a degree of productivity and scale on the job, to make sure you got enough qualified people on the job. Now, as to the contribution rates going to the plaintiffs, that's something totally different. And as we pointed out in our brief, the contribution rates go hand in hand with the benefit rates, including, for these classified employees, there's no contribution for them for the first 90 days, and they get no benefits for 90 days. But the journeyman, there's a large contribution, they get great benefits, and they get it immediately. So what I would say, Your Honor, is, as I understand your question, you're asking me is, do 2 non-journeymen make up 1 journeyman as far as contributions? No, that's not true, Your Honor. These are negotiated rates. The rates relate to the benefits that are being provided. And what's happening in this case is they want the journeyman contributions, but they don't want to pay out the journeyman rates. And that's the problem that we have here. And that's why these staffing ratios, should not apply to the contribution rates.
Thank you.
Thank you, Your Honor.
It's been good to have you all here. We appreciate your help. We'll take the matter under advisement. Mr. Clerk, we'll
A little bit. It's Osterhout. But I've answered to far further away.
tell me the correct pronunciation.
It's Osterhout.
Osterhout.
Yeah.
Good to have you with us, sir.
Thank you. I'm glad to be here. Here we go. Just no way around that, I guess.
All right. Go right ahead.
Oh, well, thank you.
No, you got the floor.
Thank you, Your Honor. Thank you for oral argument. I appreciate the chance to advocate one more time for Mr. Oakes. And selfishly, I'm happy to be anywhere, frankly. It's the first in-person appearance I've done for a claimant since before the pandemic. So it's like the old joke, glad to be anywhere. Your Honor, what I note in the docket, description of the issue relates explicitly to the consultative examiner's examination and assessment in this case as it relates to his opinion about the claimant needing an assistive device. And obviously, I'm ready to present on that, but I would like the court to please consider that the argument that we had primarily made with respect to the ALJ's finding that this claimant can engage in the arduous requirements of medium work, which is standing and walking most of the day and lifting up to 50 pounds occasionally, that these really are part and parcel of the same argument and are based on the same facts. And I especially want you to consider that even if the record were found wanting with respect to the assistive device issue, that does not mean that the ALJ's RFC finding is supported by substantial evidence. In other words, an assistive device certainly proves limitations in standing and walking and actually other limitations, but...
Assistive device, you're talking about a cane or a walker?
Yes, I'm sorry, yes, Your Honor. But the absence of a cane...
What's that issue? What is that? You said that you referred to the assistive device issue.
Pardon me, Your Honor, just from the docket that was posted, the issue was stated as whether substantial evidence supports the ALJ's finding that the consultative examiner's opinion regarding the assistive device was supported by substantial evidence. And I would like, and I'm arguing hopefully clearly enough.
As far as I understand it, the issue is whether the Social Security Administration properly denied your claim.
Well, thank you, Your Honor. That was just the concern I had when I saw more.
Part of it, I assume. That might be that somebody looked at that and thought that was important.
Well, thank you. I just wanted to clarify.
I'm not saying what it is, but you go right ahead.
Thank you, Your Honor. I just wanted to clarify that from the beginning because they're really, you can find, theoretically, I think you should find for the claimant with respect to both issues, but you can find wanting the evidence regarding assistive device and still find on this record that the ALJ did not reasonably conclude that the claimant can stand and walk all day in a job. I'd like to address briefly, I hope, and maybe never again have to talk about this issue of reweighing the evidence that SSA repeats many times in its brief. I certainly understand that that's a tension in these kinds of judicial review related to Social Security decisions, but it's long been quite clear that two exceptions to quote-unquote reweighing the evidence is when the ALJ has applied an improper standard in weighing the evidence and or when the findings themselves are unreasonable, illogical, or just not based on an accurate description of the evidence in the first place. And those are the linchpins of the claimant's arguments to this court. And I think it's hopefully helpful to hear again that there are numerous uncontested facts here. The claimant has very little treatment owing to the fact that he does not have insurance or money to pay for treatment, so the ALJ agreed that he needed to schedule a consultative examination. That was conducted, and
the ALJ sent him to see a doctor, in other words.
That's correct, Your Honor. Thank you.
There was a hearing before the ALJ, correct, on his disability claim.
Yes, sir.
And before terminating the hearing, the ALJ decided to send him to the doctor, for the consulting doctor.
That's correct, Your Honor. This was on motion, repeated motion, I might add.
The only evidence had been his testimony and records relating to emergency room visits?
Yes, Your Honor, just a few.
Two emergency room visits?
That's right, two.
Two emergency room visits several months before.
It kind of boils down to this. He got the report and he disregarded it, and it looks like it's a situation that we have encountered many times before and bemoaned it, really. And that is to the tendency of an ALJ to overstate claimants' residual functional capacity and ability to work based on their daily activities. Is that the bottom line?
This was certainly one of the rationales that the ALJ employed, was a sort of general description of this claimant as quote-unquote being able to do things.
What's wrong with that?
Well, nothing if what those activities prove is that the claimant has a robust ability to perform activities all day long, every day. The issue in these cases is not what the claimant can do when they can do. It's what they can do day in, day out, 5 days a week, 8 hours a day on a regular and continuous basis. And there's, of course, many cases that have noted that the claimant's ability to perform transitory or sporadic daily activities is not usually illustrative of what the claimant can do day in and day out. I might add that even taking that at a one-to-one relationship, none of the activities that are relied upon by the ALJ in this case even remotely come to anywhere near a medium RFC of lifting 50 pounds. You know, washing some dishes or sweeping a floor. I think going to the grocery store was one of the items that was listed. None of these, even on their face, even if the claimant did them all day long every day, which of course not even the ALJ said that, would support a finding that the claimant can stand and walk all day and lift 50 pounds occasionally and 25 pounds frequently.
But
So-
there was a little more than that, right? Didn't the doctor who assessed him assess generalized motor strength, right? There were some findings about upper extremities, lower extremities.
Yes, Your Honor, I was just going to sort of launch into my little litany of what's in this report that's being described as inconsistent with Dr. Samia's conclusions. And what's in there is what you just mentioned about strength. I think very significantly, the observation of a shuffling, limping, slow gait.
So the doctor said 5 out of 5 for upper body strength, right? And 4 out of 5
Correct.
for
Your Honor.
lower body strength?
Correct.
So that's not just daily activities, right? That's a doctor's report that he retains full strength in his upper extremities and close to full strength in his lower extremities.
That's correct, Your Honor, although not entirely full strength. And there, this is before we look at observations of the shuffling, limping, slow gait, the fact that the claimant supported his upper body in a seated position by resting himself on his arms, decreased range of motion, tenderness throughout the back, and then, of course, the finding itself regarding the need for an assistive device. Now, on this point, Dr. Samia used the phrase appears to need the assistive device. Now, I think, and I'm sorry, and so SSI implies on numerous occasions in a sort of disparaging way that this isn't really much of an observation, but I submit that it wouldn't be if you or I made it, but if a doctor is making an assessment based on what he's seeing in the context of where he's already identified numerous other findings that are consistent with his report, or assessment, I'm sorry, that what appears to a doctor is a far different thing than what appears to me or a judge or, frankly, an ALJ in one of these cases. And I, to go back, I would agree with Judge Floyd that what happened in this case primarily is that the ALJ, as you may recall from the briefs, when he finally agreed to schedule this consultative examination in a case where the claimant couldn't afford treatment, therefore couldn't submit better evidence of his case, the judge indicated that we'll see what happens. Well, what happened was that a report was generated that patently contradicts the ALJ's findings in this case. I don't think there's even a dispute.
The doctor's report.
That's right, Your Honor. That patently contradicts the ALJ's RFC. I don't think there's a dispute here. A lot of energy's gone into defending the ALJ's decision to find it unpersuasive. But when you look at it from the standpoint of whether the correct standard is being applied to evaluating this evidence, or when you apply the simple is test of just whether it's reasonable and whether it makes any sense logically, or whether it accurately describes the evidence that is confronted in Dr. Samia's report, that the ALJ's decision does not come close to meeting even that more basic test. In one of these cases, now, and I'm sure the court has considered some cases involving the new opinion evidence rule, the opinion is only assessed initially for its persuasiveness, based on whether it's consistent with the record and supported by, and the opinion supported by the findings. And we've already shown, I've already shown that it did happen here. And the new opinion evidence rule did not attempt to, or cannot in any way be twisted to have changed in any way, shape, or form the standard of review that a district court applies. In fact, very explicitly to the contrary, SSA agrees that that the ALJ's explanation still has to be supported reasonably in the record. It's plain that a doctor could look at what Dr. Samia looked at and reasonably come to the conclusions that he came to in this case. And all we have are, with all due respect, some made-up inconsistencies in the ALJ's rationale between examinations that occurred months and even over a year prior to Dr. Samia's report, and even none of that considers the fact that this minimal evidence was conducted in an emergency room, that this evaluation was performed by a disability examiner who SSA trains and I imagine supervises.
Is the examining physician or the consulting physician, whatever you call him, is his report entitled to more weight because he was selected by the Social Security Administration?
No, Your Honor, I can't honestly say that.
Don't say that.
He could be...
He is the only doctor that gave him a physical.
The only doctor that assessed anything based on examination. In fact, the only doctor, period, because of this dearth of information in the record that's related to the claimant's financial situation, the initial reviewers at the state agency could not even conclude that there was enough evidence to make an assessment one way or the other. So that's the way that the case actually came before.
The ALJ rejected Dr. Samia's.
Yeah, well, found it unpersuasive. That's right. As not consistent.
Found it unpersuasive.
That's right. I mean, technically speaking, that's what the ALJ did here under.
What did he say about this assistance device?
Well, he found that he employed, that's why I said these two overlap considerably. He applied essentially the same argument that it wasn't consistent with Dr. Samia's examination, but then also that it had not been prescribed. Now, that's an interesting, I would say even very unfortunate looping that the ALJ is doing here. We don't have enough records because the claimant can't get treatment. We send him to a doctor. That doctor says he needs an assistive device, and now the ALJ's reaction to that is to say, well, he didn't have a prescription. Now,
well, he didn't say prescription. He said he wasn't prescribed.
Well, that it was. I'm not seeing the.
What?
I'm not seeing the difference.
Well, maybe there is no difference.
Okay.
I'm just trying to get to the specifics.
I think SSA would have to agree that.
Did you read that the absence of a written prescription?
Yes.
For a walker or a cane or would this be for an assistance device?
I'm happy to hear another theory.
What was the prescription? What was it that wasn't prescribed?
An assistive device.
An assistance device.
Right.
Right.
So I'm happy to hear another theory about it, but I can't but conclude that the ALJ is invoking there, at least in part, not entirely, but in part the lack of a prescription. I don't think SSA will defend the proposition that you must have a prescription to demonstrate that a cane is medically necessary. What you actually need is an opinion supported by evidence that says that the cane is necessary, especially nowadays when anybody can go to Rite Aid or Walmart or whatever and just buy a cane out of a rack at a store. Now, that doesn't mean the claimant doesn't have the burden of showing that it's necessary, but it definitely leaves out of the equation more so than, let's say, 20, 30 years ago that you needed a cane for it to be considered legitimate. My time's run out. I'm obviously happy to
You have some rebuttal time.
Okay, thank you, Your Honor.
Any further questions?
No.
Thank you very much, sir.
Thank
Ms. McKay?
Good morning, Your Honor.
Good to have you with us, Ms. McKay.
Thank you, Your Honor. May it please the court, Natasha McKay on behalf of the acting commissioner. The ALJ in this matter reasonably considered the evidence presented, 18 pages of medical records, and while the record is short, it is sufficient enough for the ALJ to make her determination. Over the 3-year period in question, Mr. Oaks is seen by 3 medical professionals. The ALJ considered their observations and their findings.
You're counting the 2 emergency room visits.
That is correct, Your Honor. They are, in fact, medical professionals.
They were what, almost a year before the consulting physician?
That is correct, Your Honor.
And then the consulting physician who the claimant was referred to by the ALJ
Yes, Your Honor.
during the conduct of the hearing.
Yes, Your Honor.
Okay?
The ALJ considered those observations and findings and included limitations in the RFC to accommodate Mr. Oaks' severe impairments and associated symptoms that were supported by the evidence presented. What was not supported was Dr. Samia's ultimate finding that Mr. Oaks required an assisted device for ambulation or for balance. It was not included because it was not supported.
Well, he said he needed an assisted device to get around.
Well, what Mr.
He said that to her, didn't he? To the doctor. He said that to the consulting physician.
Well, what he says on page 255 of the record, Your Honor, or what was confirmed by Dr. Samia, is that Mr. Oaks confirmed that he was able to ambulate without an assisted device and able to walk a block. And at the onset of this case, Your Honor, Mr. Oaks is a fairly young individual. He's about 48 years old. He's alleging disability due to hypertension, to gout, to back pain. He's a cook. He's testified to that. He takes over-the-counter medication. He does not have a personal relationship with a primary care physician, and he has presented to the emergency room on 2 occasions to seek care. And what the evidence before us will show is that the ALJ's finding that Mr. Oaks did not require an assistive device for ambulation or for balance was reasonable. And here's why. Directing the court's attention to page 237 of the administrative record. This is the first instance where Mr. Oaks presents to the emergency room. And if I may, normally when we present to the emergency room, we show up as our worst selves. We're saying, I am in need of urgent care, help me, this is an emergency. Mr. Oaks presents to this first emergency room visit. He complains of back pain, radiating pain, moving down his leg. His examiner in that instance indicates that Mr. Oaks is able to ambulate. Nowhere in that record does it show that Mr. Oaks presented with an assisted device for ambulation or for balance. In fact, the examiner indicates that Mr. Oaks demonstrates normal gait, his manner of walking, normal motor strength, full range of motion, no neurological deficits. Then we have the December 2018 emergency room records. Those are on page 246 of the administrative record. Mr. Oaks presents again as what we believe is his worst self. And nowhere in those records is it indicated that Mr. Oaks presents with an assistive device for ambulation or for balance. In fact, he was examined by a physician of internal medicine, Dr. Parikh, who indicated that Mr. Oaks demonstrated normal strength, normal range of motion, no indication that he presented with an assisted device for ambulation or for balance. And then we have...
Samia, I thought Dr. Samia, I have in my notes that his report concluded that Oaks may have difficulty with rough and uneven surfaces, and in keeping with the report, that he used, quote, both a cane and a walker at home, unquote, and it appears an assistive device is needed for both ambulation or balance. The or doesn't make sense with the both. But and that's an unquote, and I'm quoting from the report of Dr. Samea, the consulting physician, wrote that.
Yes,
right?
Your Honor. Yes, Your Honor.
And the ALJ didn't accept that.
Well, Your Honor, before that, what I was discussing, there's two answers to that.
But he says that Oaks reported to him that he used both a cane and a walker at home, and that it does appear an assistive device is needed for both ambulation or balance. Now, that's what he said.
Yes.
Okay.
But prior to that, Mr. Oaks was seen by Dr.
I thought you said there was no evidence of any of that.
No, Your Honor. Prior to that, Mr. Oaks was
Not
seen
only
by.
says that that's what Oaks said, but that's what the doctor said.
Well, what Mr. Oaks said at Dr. Samia's, while he was observed by Dr. Samia, what he concluded or what he confirmed was that he was able to walk without an assisted device. That's what Mr. Oaks confirmed on page 255.
Well, he reported that he used a cane and a walker at home. That's in the quote of the doctor. He used a cane and a walker at home. And it does appear an assistive device is needed. But says none was prescribed. And I don't understand what that means. Does that mean a prescription? Or does that mean required or needed or something? Does it mean something other than prescribed?
No, Your Honor, it doesn't mean that a prescription is required. A prescription is required, and certainly it is not. What the ALJ was doing.
But the ALJ said that there was, as a matter of evidence, I think, there was no prescription. There was no assistive device prescribed by Dr. Samia, is the way I was reading it.
Yes, Your Honor, but that.
Is that correct reading on my part?
Well, what it does not mean is that a prescriptive device was required. The ALJ was.
No, he said a prescription was not prepared.
Yes.
With prescriptions, I think of that is where I'm going to go to the drugstore or the medical supply store and pick up a walker or a cane.
What?
Is that right?
Well, Your Honor, what was happening?
There was none written by Dr. Samia.
And there did not need to be, Your Honor.
Well, I'm just trying to ascertain the facts. That's your position. It did not need it to be, he didn't need to have a prescription written.
Yes, Your Honor.
All right. You say that because he didn't need a walker or a cane?
That's not there isn't a requirement that a prescription was needed.
The doctor said he appears he needed an assistive device for ambulation and balance.
Yes.
Well,
but even there,
prescription.
Even there, Your Honor, where that was noted, even in that examination where Mr. Oaks was found to be leaning over on the examination table or presented with what was called a shuffling gait, even there in that examination, the first one where Mr. Oaks actually presents with an assistive device, even there, he confirms that he could ambulate without it. And that is on page 255 of the record. And that's also stated by Dr. Samia as well. So what the ALJ was doing in that instance was giving a balanced review of the evidence and showing why her consideration of the evidence and her findings in the RFC were reasonable.
So how often do the ALJs reject the medical reports of their own doctors?
Well, there are two answers to that. First, the consultative evaluation, the CEs, they're not our own doctors. They are not employees of the agency. They are independent evaluators.
They're not all doctors?
They're not agency high. Yes, they are not agency.
But they are doctors.
They are, yes.
They are medical professionals.
Yes, Your Honor.
And the ALJ is not a medical professional.
I'm sorry, Your Honor.
The ALJ is not a medical professional.
Correct, Your Honor.
ALJ is a lawyer.
Correct,
I suspect.
Yes.
All right. Go ahead.
So here we are where,
And we got a lawyer rejecting the medical evaluation of a trained physician. Is
Not
what
rejecting.
we have here, and the only one that's performed a physical examination on this fellow.
well, first, the ALJ did not reject the opinion entirely. One facet of the opinion, the use of an assistive device for ambulation, and again, that was not adopted because it was not supported. However, there were
That's
other.
the only thing that was rejected?
Well, that's the only limitation that was provided.
That's the only thing that was rejected in the whole report?
Yes, Your Honor. That's the only limitation that was actually provided. It appears that Mr. Oaks requires an assisted device for ambulation and for balance.
Right.
That is the only limitation provided by Dr. Samia. That's the first part. The second part is he is not the only examining physician in the record. Dr. Parink examined Mr. Oaks in December of 2018 in the emergency room. He is a doctor of internal medicine and still a doctor. So the indication by our opposing counsel that there was only one physician in the record is simply not accurate. He was seen by other medical professionals, and their opinion.
Only
and
other
their,
two times he'd been seen a doctor was almost a year earlier in emergency room.
May of 2018, December of 2018, and then the CE in September of 2019. There isn't a lot of evidence, but what's here is sufficient enough for the ALJ to make her determination, and that's what she did.
Does the regulation allow the ALJ to give controlling weight to a doctor's opinion, any doctor's opinion?
Well, we are operating under the new regulations.
Right.
So we're not operating regarding weight, but the
The regulation forbids the ALJ from giving controlling weight to any medical professional's opinion, right?
Well,
The regulation requires the ALJ to assess the persuasiveness of the opinion, right? Supportability, consistency, et cetera.
correct, Your Honor.
The ALJ can't say, you're a doctor, you know what you're doing, I'm not a doctor, end of story.
Exactly, Your Honor. So the question then, the ultimate question
They
is,
got to explain it when they reject it.
yes, but again, only one facet of the opinion was rejected. There was only one limitation noted. And as we can see throughout the record, there's not enough support for an assisted device. And even if a reviewing court would have weighed the evidence differently, even if a reviewing court would have determined the evidence differently, it's not the job of the reviewing court. The task of resolving conflicts in the evidence is that of the ALJ. And as we can see, the district court affirmed the commissioner's findings and found that there was substantial evidence to support the ALJ's RFC. And so here as well, we're asking for these reasons that the honorable court affirm the district court's judgment. Thank you.
Any other questions? Thank you, Ms. McKay.
Thank you, Your Honor.
Mr. Oosterhout?
Thank you. Just a few comments. And to start at the end, I mean, the idea that the issue in this case is whether the claimant needs a cane or can just stand and walk just fine is just not an accurate statement of the evidence that was before the ALJ. The claimant described very significant standing and walking limitations during his testimony that is supported in Dr. Samia's assessment. It appeared to him as a doctor that the claimant needed to use this cane that he was describing. I don't read personally Dr. Samia's report as suggesting that the claimant always needs it. In fact, quite clearly in context, he didn't have it with him that day.
Well, we spent way too much time talking about this cane. He applied for disability benefits.
Yes, sir.
And the question is, what capacity does he have to perform work?
That's right.
And I guess the only reason the cane comes into effect, that in order to do things during the day as a job, he'd have to have a cane. But forget that.
Yeah.
The question is, was he disabled?
Right. And so here, the item for review is the ALJ's finding, well, two really, that the RFC finding itself for medium work, which as you probably know, is basically standing and walking all day or most of the day while lifting 50 pounds occasionally and 25 pounds frequently. So that's the RFC that's at issue. that RFC is not supported by the opinion that the claimant needs to use a handheld assistive device to move about, even if only occasionally, and is certainly not consistent with the claimant's self-description of his limitations, which I agree with you, Judge Floyd, we didn't talk about enough today. The claimant's description of his symptoms and limitations must be credited if it's, number one, if it's generally consistent with the types of medical conditions that the claimant has, and that's a given in this case because the ALJ found as such. And then in the second part of the test under 404-1529, the issue is whether the claimant's subjective complaints are consistent with the record in a more general way, but it is not the same. When you're arguing the claimant's self-described limitations at step 2 of 404-1529, it is not the same as saying that we're arguing for disability based on subjective complaints alone. That's already been dispensed with by the step 1 finding. So at step 2, we consider everything. And in fact, the ALJ gave surface attention to all of these. He rejected Dr. Samia's contrary opinions, we argue, for illogical and unreasonable reasons. He made a big show of the claimant's supposedly robust daily activities as being consistent with a finding that the claimant can perform medium work. And then, and it happened again in the presentation today, we keep looping back around to the lack of medical evidence in this case as supporting the ALJ's decision when the whole case arises as a result of that the ALJ even acknowledged that the claimant wasn't able to get treatment. And so he's not had the kind of treatment that we see in lots of cases. That's absolutely true. That's a given. And so we're left in this case with the only full evaluation of the claimant's limitations. And I might add, in other contexts, SSA will emphasize that these doctors aren't just sort of independent and we don't really have much to do with them. That's not true at all. They're under contract and they're trained. And in other contexts, they will argue that they're trained in disability evaluation and that they're experts in Social Security's programs. And that's true. That's what the regulations say. So that's the context in which Dr. Samia sees Mr. Oakes.
So you're saying Dr. Samia should be given more weight than the ER doctors?
Well, okay, but yes, but not for quite the reason that I think you picked up on. Your Honor, number one, there's no question whatsoever that Dr. Samia's evaluation was more complete in the sense that he discussed a lot more things. And you might note that nothing SSA has said yet, here today or in its briefs, directly challenge what Dr. Samia found, what he saw. They're not saying that he didn't see what he saw. They're saying that somebody else saw something different. Months, 15, 16 months earlier than Dr. Samia's examination. That could very well be true. Because don't forget, the primary condition in this case is degenerative disc disease. Well, you take degenerative plus time, and then the most reasonable thing to conclude from that is that it's very possible that in 2 years before the hearing at an emergency room visit that the guy had much less problems than he had several years later when Dr. Samia saw him. I think that's a perfectly reasonable conclusion to draw. But that's not what the judge did. The judge really is reversing the whole thing. He's saying, kind of almost putting Dr. Samia's opinion in the hot seat from the beginning as an assumption, and then comparing the inconsistent statements from previous to it. But you could just as easily do it the opposite. You could just as easily put the May 2018 emergency room doctor in the hot seat and then argue that Dr. Samia's opinion contradicts it. The point is that the only reasonable conclusion is that with a degenerative condition and the claimant getting older, by the way, he had passed age 50 during the pendency of this case, that the more significant limitations that Dr. Samia found are based on The training that Dr. Samia has by SSA.
Can I ask you about that? You mentioned Dr. Samia's training.
Yes.
Previously, that he's trained to assess for this purpose, and you just mentioned limitations. Should we read the doctor's opinion, the doctor's evaluation, as setting out the universe of limitations? The government pointed out that the only limitation in Dr. Samia's opinion was that he may need a cane and may have trouble with inclines or stairs. Is that the universe of potential limitations? Is it significant that the doctor didn't say he can't lift over a certain amount? I'm not.
So yes,
sure.
I meant to. You try to pick what to talk about in a short period of time. Yes, I won't say that Dr. Samia's opinion necessarily covered everything that I wished that it would have. I wasn't the rep at the administrative level. There might have been a way to get more information from Dr. Samia, but that didn't happen. I do believe.
But I guess my question is not just like, was Dr. Samia's opinion the ideal for you, but for that, when the ALJ is assessing what limitations are necessary.
Well, I didn't mean to make it personal. I think that.
Add to, I really don't know the answer to this. I'm just trying to find out. Can the ALJ read the doctor's opinion and say, the doctor didn't say that this man has a lifting limitation.
No, he didn't.
But it sounds like, based on all the evidence, that might be appropriate? Or are we just looking at the only limitations that this doctor, who's trained to find limitations, found was may need a cane occasionally or may have trouble with inclines? Is that the universe of limitations?
No, in fact, that was one of the first thing that I tried to address when I got back up, which is that you can't think about someone who needs a cane who can just walk. The choice isn't between whether he needs a cane or whether he can walk as much as he wants to. There's clearly something implied here. And there's also the fact that the ALJ also made a finding in this case that the claimant's testimony was not credible, I guess is the word that we have to use in these cases, even though that's not technically correct. And so a credibility finding has to take into account all the evidence. And all the evidence included, in this case, Dr. Samia's opinion, which absolutely is consistent with the claimant's self-description of standing and walking limitations. So I didn't mean to answer your question as though what I had wished for. I was trying to answer that, ideally, I think even Social Security would say that you get sort of an item-by-item description of limitations across a broad range of work-related functions, but that didn't happen here. That's absolutely true.
Thank you very much, sir.
Thank you, Your Honor.
Good to have you here.
Thank you.
I appreciate counsel's arguments very much, and if we could do so, procedure here normally is we come down from the bench at this point and shake hands with the lawyers and greet you and tell you you've done a fine job. But we've suspended those rules for the.
Well, I remember that from several years ago. I was sort of hoping that you'd gotten back to it, but that certainly understood why.
Suspended for the pandemic, but
yeah.
Next time.
All right, thank you, sir.
We'll do that. Good to have you here. Mr. Clerk, we'll adjourn court until tomorrow.
This honorable court stands adjourned until tomorrow morning at 9:30. God save the United States and this honorable court.